Hi, I'm Philip Hundl, and I'm an attorney in Texas that my practice area focuses on land litigation, which could include partitions of property, easement disputes, and also representing landowners facing eminent domain proceedings or condemnation proceedings. Many of you have probably seen my videos on a lot of those different topics about pipeline easements, high voltage transmission line easements, and partition cases. What some folks don't know about me is I am a mediator as well, and I want to talk more about alternative dispute resolution or ADR or mediation, and why that is important in land disputes. Um, and when I talk about land disputes, it could be anything related to, like I said, an easement dispute about an ingress and egress from a neighbor getting to their back to their property across someone else's land, or a partition case, oftentimes a family partition case. Large family or even a small family, 2 or 3 family members dividing up what was once the family ranch or farm, and um, attempting to try to do that, um, sort of going to trial and letting a judge or jury determine that. So, the law in Texas and the courts encourage mediation. There's different forms of media or alternative dispute resolution, but for the most part, the most common is mediation or formal mediation. Before there was formal mediation and mediators, normally parties would just attempt through their attorneys informally settle or mediate cases, and that can be very successful. But oftentimes, it is helpful, and the courts have identified this and recognized that it's helpful to have a neutral third party in the form of a mediator that is able to go in between the two groups and try to help facilitate a deal. So, um, what I want in most cases, when they're in litigation, before having a trial, a court is going to encourage and ask, and sometimes even order the parties to go to mediation. And either party can have, has the ability to ask the court to order mediation. So that's always an option. So um, I want to talk about, and in this video series, I want to give, I call basically my top tips uh, for successful land dispute uh, resolutions or mediations. So these are top 10 things that I think as a mediator I've seen, and even as an attorney going to mediations, have seen help cases get settled. If this wasn't done in a case, sometimes before mediation begins, and there is a lot of groundwork to lay before mediation begins, these cases wouldn't have gotten settled. So with that, I call it a top 10. Maybe it turns into a top 12, or we cut it down to top 8. But let's start, and we'll go through a few of these. So number one, familiarize the mediator with the dirt, with the land. What's at issue here? What is it one track? Is it multiple tracks? What are the tracks called? How do people refer to them? Well, that's the ranch, or that's the home place land, or that's the back pasture, or the hay meadow, or whatever everybody refers to it as. Start getting the mediator familiar with the references and try to stick to those same references. If everyone's calling it the 20 acres, don't all of a sudden call it the Brown track uh, as opposed to the 20 acres. Try to stick to the same terminology, and that's going to help the mediator, because the mediator, um, you know, he's going to be hopefully familiar with the case before the day of mediation, because the parties will send him, and most mediators will ask for this, a summary of the case or a position statement. But once again, try to stick to similar names. Location. Where are these tracks? What are these tracks? What are their attributes? Is it wooded? Is it pasture? Is it pasture with some trees, no trees? Improvements on the property. A piece of property with, a pasture with, or a hay, irrigated cropland as opposed to non-irrigated, extremely important. Pastures with working pens and the like. extremely different than a pasture that doesn't have it. And next to it, a pasture that has a working pen that it's owned, and we're trying to divide up and partition. So those are really important things. Also, do some of the parties live next to these properties that are, let's say, in a partition case? Well, someone living right next to some jointly owned land that they're partitioning, that's an important factor as to, dividing up the land. And so you want the mediator to know all those things. Any ownership issues, someone recently possibly passed away, and so maybe the ownership is being transferred to the kids by will, and so the kids are now owners of the property, but the will still needs to be probated, so possibly the mediation needs to be pushed off. And then, what are the kind of personality of the parties, the idiosyncrasies of the parties, to give the mediator, you want to call it a heads up, setting his expectation on the different personalities and what he's going to have, the challenges he's going to have, extremely important. And then for, the attorneys representing each side to talk to the mediator beforehand, either in person or over the phone at least. Now, there have been some times as a mediator that both attorneys have wanted me to come and look at the property so that it's going to be clear to me what they're talking about when we're in mediation. And sure, I've done that. I also, a lot of times, just by having a conference call with both attorneys or either lawyer, it doesn't matter, it doesn't have to be both attorneys, or sometimes where there's 3 or 4 parties, it doesn't have to be all the attorneys. Just looking at a Google map and going over and becoming familiar with what they're talking about with the road on the north side or the north boundary line or whatever. So tip number 1, familiarize the mediator with the dirt. It's extremely helpful for me, the mediator, to know more about the property. Tip number 2, don't come to mediation empty-handed. Lawyers, this is kind of directed to the lawyers representing parties. Bring what you need to mediation. The worst thing is, we're wanting to start describing tracts of land, and we need those deeds, we need those easements, we need those plats, we need that information so that, and I oftentimes will bring color over aerials or even on a laptop to show the mediator at mediation. And then with those surveys and plats, oftentimes there's we mark up a drawing or plat indicating who gets what track. And it, of course, is not going to be to scale or properly drawn like a surveyor would, but we'll reference, the acres that each person may get. But we can't do that, or you can't do that, attorneys, if you don't bring that information to the mediation. So, bring the deeds, bring the legal descriptions, bring the plats, bring the surveys, bring the maps, bring the aerials, all extremely important. So it's going to think there's one other document that oftentimes I bring, and I'm just thinking these I will oftentimes have these, a proposal already drawn out possibly on an aerial or a plat, and sometimes many options, and I'll hold that back as an attorney so that if that comes into play, I've got that document. The worst thing to do is trying to create a document at mediation or back and forth trying to get that information from the attorney's office. So, once again, don't come to mediation empty-handed, attorneys. Bring, and frankly, just by bringing your whole file is probably what you need to do, but also have it in electronic form too. So with that, some tips. We're going to continue this video series with some further tips in another video clip. So if you've enjoyed this, click subscribe and like the video. That will help me. If you've got some comments or feedback, please provide those to me. Once again, I read those comments and I take into consideration so that I can provide really the best, helpful content that I can. Thank you.